Connecticut has one of the more heavily regulated tenant screening environments in the Northeast, shaped by strong fair housing protections, source of income mandates, and a legal culture that actively protects tenant rights. The governing framework includes Connecticut's landlord-tenant statutes, found in Connecticut General Statutes Title 47A, along with the Connecticut Fair Housing Act, FCRA, and an enforcement environment that's among the most active in the region. If you're screening tenants in Connecticut, you need to understand a framework that imposes more restrictions than many neighboring states. Let's start with application fees. Connecticut has a specific provision that affects application fees. Under Connecticut law, landlords are prohibited from charging prospective tenants any fee in connection with the rental application other than a security deposit and first month's rent. This means Connecticut effectively bans application fees. Landlords cannot charge a screening fee, credit check fee, or application processing fee. This is one of the most restrictive fee frameworks in the country, similar to Massachusetts, which also prohibits application fees. The cost of tenant screening must be absorbed entirely by the landlord as a business expense. Charging any fee to a prospective tenant before they move in, other than the security deposit and first month's rent, violates Connecticut law. Because landlords bear the full cost of screening, maximizing the value of every screening report is critical. Use a provider that delivers comprehensive results, credit, criminal, eviction, and rental history, in a single report at the lowest possible cost. The screening expense is a cost of doing business in Connecticut, and building it into your overall operating budget is the only compliant approach. Criminal history screening in Connecticut has been affected by the state's broader criminal justice reform efforts. Connecticut does not have a comprehensive statewide ban-the-box housing law with the detailed step-by-step procedural framework found in places like Washington, D.C. or Chicago. However, several important provisions affect how criminal records can be used. Connecticut enacted significant criminal record reform through its Clean Slate legislation. Under the Clean Slate provisions, certain criminal convictions are automatically erased after specified waiting periods, without the individual needing to petition the court. Misdemeanors are automatically erased after 7 years, and certain felonies after 10 years. Provided the individual has not been convicted of any new offense during the waiting period. Once a record is erased under Connecticut's Clean Slate law, it is treated as if the conviction never occurred, and landlords cannot consider erased records in screening decisions. Connecticut's automatic erasure is one of the most comprehensive Clean Slate laws in the country, similar to Michigan's Clean Slate Act. The automatic nature means records are being erased on an ongoing basis as individuals meet eligibility criteria. Screening providers must filter erased records from their reports. Landlords should verify that their provider is current with Connecticut's Clean Slate provisions. If your provider returns records that have been automatically erased, you're receiving information you shouldn't have. Connecticut also expanded its standard expungement and pardon provisions. Records that have been expunged or pardoned cannot be considered in screening. Connecticut's Board of Pardons and Paroles actively processes pardons, and a pardoned offense is treated as if it never occurred. Connecticut legalized recreational marijuana, and the state enacted specific protections. Under the marijuana legalization framework, landlords cannot discriminate against applicants based on legal cannabis use. While landlords can prohibit marijuana use on the premises through lease provisions, particularly in smoke-free buildings, using historical marijuana records for conduct that's now legal as a basis for denial creates risk. Marijuana-related records for conduct legal under current law should not factor into screening decisions. Hartford, New Haven, and Bridgeport have been active in tenant protection discussions. While no Connecticut municipality has enacted a comprehensive ban-the-box housing ordinance as of this recording, the political environment in Connecticut cities strongly favors additional protections. Landlords in Connecticut's urban centers should monitor local developments. HUD's 2016 guidance on criminal history and disparate impact applies in Connecticut. Hartford, New Haven, Bridgeport, and Waterbury have diverse populations, including significant African American, Hispanic, and Caribbean communities, and criminal history policies that disproportionately affect these groups face scrutiny. Connecticut's enforcement environment is active, and fair housing organizations regularly file complaints. Blanket rejection policies are particularly risky in Connecticut's legal culture. Source of income protection in Connecticut is well established and strongly enforced. Under the Connecticut Fair Housing Act, found in Connecticut General Statutes Section 46A-64C, landlords cannot discriminate against applicants based on their lawful source of income. This includes housing choice vouchers, Social Security, disability payments, veterans benefits, supplemental security income, temporary family assistance, and any other lawful income source. Connecticut's source of income protection is statewide and applies to all landlords. The protection is actively enforced by the Connecticut Commission on Human Rights and Opportunities, known as CHRO. Fair housing testing is conducted regularly throughout the state. Organizations send testers posing as voucher holders to identify discriminatory practices. Landlords who state they don't accept vouchers, in any form, in any communication channel, face enforcement action. Connecticut has a particularly strong enforcement track record on source of income discrimination. CHRO has pursued significant cases and has a reputation for thorough investigation. Landlords in Connecticut should assume that any discriminatory statement or practice will eventually be identified and pursued. Landlords must evaluate voucher-holding applicants on the same basis as market-rate applicants. If the voucher payment plus the tenant's personal contribution meets the income requirement, the applicant qualifies. Setting income thresholds that effectively screen out voucher holders when the combined income would cover the rent can constitute discrimination. For credit reports, Connecticut follows FCRA requirements for permissible purpose and written consent. The adverse action process follows federal requirements. Given the prohibition on application fees, the landlord bears the full cost of pulling credit reports and must still provide the standard FCRA adverse action notice if denying based on credit information. Connecticut's fair housing protections under the Connecticut Fair Housing Act are among the broadest in the region. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity and expression, disability, familial status, marital status, age, ancestry, lawful source of income, and status as a veteran. The breadth of these protections creates a screening environment where virtually every applicant characteristic is potentially protected. The veteran status protection means landlords cannot discriminate against applicants based on their status as current or former military members. Combined with SCRA protections, military applicants in Connecticut have robust protections. Connecticut also has specific protections for victims of domestic violence. Under CGS Section 47A-11E and related provisions, landlords cannot deny applicants based on their status as victims of domestic violence, sexual assault, or stalking. Landlords cannot consider police calls, restraining orders, or disturbances at prior tenancies that were attributable to the perpetrator rather than the victim. Connecticut has a strong anti-retaliation provision under CGS Section 47A-20. The statute creates a 6-month presumption of retaliation if a landlord takes adverse action after a tenant exercises a legal right. The presumption requires the landlord to overcome it with clear and convincing evidence, one of the higher evidentiary standards used for anti-retaliation provisions. While this primarily applies to existing tenancies, it reflects Connecticut's strong commitment to protecting tenants who exercise their rights. Connecticut's Fair Rent Commission system is unique and relevant to the screening context indirectly. Cities including Hartford, New Haven, Bridgeport, and Stamford have fair rent commissions that can review rent increases deemed harsh and unconscionable. While these commissions don't directly regulate screening, they reflect the active regulatory infrastructure that monitors landlord practices in Connecticut cities. From a practical standpoint, Connecticut has a tight and expensive rental market, shaped by its position between New York City and Boston, strong healthcare and insurance industries, and significant wealth alongside pockets of deep poverty. The Stamford-Norwalk-Greenwich corridor in Fairfield County has one of the most expensive rental markets in the country. The economy is driven by financial services, major hedge funds, investment banks, and corporate headquarters, professional services, and New York City commuter demand. The applicant pool in this corridor tends to be well qualified, with strong credit and income profiles. Rents are among the highest in New England outside of Boston. Bridgeport, the state's largest city, has a more affordable and diverse market. The city has a significant Hispanic and African American population, and a substantial portion of the rental population receives housing assistance. Source of income protections are particularly relevant in Bridgeport, and criminal history screening criteria must be carefully documented and consistently applied given the city's demographics. Hartford, the state capital and insurance capital of the world, has a diverse market driven by the insurance industry, including the Hartford, Aetna, Cigna, and Travelers. Healthcare, including Hartford Hospital and Connecticut Children's, government, and higher education. Hartford's rental market is more affordable than the Fairfield County corridor, but still tight relative to its size. The city has a predominantly minority population, and fair housing compliance is critical. New Haven, home to Yale University, has a rental market driven by the university, healthcare. Yale New Haven Hospital is the largest employer in the New Haven area, biotechnology, and research. Yale's presence creates both student demand near campus and professional demand throughout the city. New Haven has a diverse population and active tenant advocacy organizations, including the Connecticut Fair Housing Center, which pursues fair housing complaints statewide. The Connecticut Fair Housing Center is one of the most active fair housing organizations in the region. The center conducts fair housing testing, files complaints, pursues litigation, and provides education. Landlords across Connecticut should be aware that the center actively monitors screening practices and takes action against violations. Waterbury, New Britain, and Meriden have more affordable markets with diverse populations and higher concentrations of tenants receiving housing assistance. Screening in these communities requires consistent criteria applied without bias. Middletown, home to Wesleyan University, Storrs, home to the University of Connecticut, New London, home to Connecticut College and the U.S. Coast Guard Academy, and other college communities have student-influenced markets. Naval Submarine Base New London in Groton is the primary East Coast submarine base and generates significant military rental demand. Military tenants at the subbase include submariners, nuclear-trained personnel, and their families, generally well-qualified applicants with strong and verifiable income. Landlords near the subbase should understand military income documentation, LES, and BAH rates. New London area BAH rates are moderate to strong. The shoreline communities, including Guilford, Madison, Old Saybrook, and Essex, have more affluent markets with limited rental inventory. The Litchfield Hills and northwestern Connecticut have small markets influenced by weekend tourism and second home demand from New York City. One critical best practice for Connecticut landlords: never charge an application fee, screening fee, credit check fee, or any other fee to a prospective tenant beyond the security deposit and first month's rent. The prohibition is clear and enforceable. Budget your screening costs as an operating expense. The most efficient approach is to find a screening provider that delivers comprehensive reports at the lowest possible cost and absorb that cost as part of your business operations. Another critical best practice: never state in any form that you don't accept vouchers or government assistance. Connecticut's source of income protection is among the most actively enforced in the country. CHRO investigates complaints, and the Connecticut Fair Housing Center conducts regular testing. Remove any language from listings, websites, applications, or policies that suggests you don't accept Section 8 or government assistance. Train every person who interacts with prospective tenants, from the first phone call through lease signing, that source of income discrimination is illegal. A third best practice: verify that your screening provider is current with Connecticut's Clean Slate automatic erasure provisions. Records that have been automatically erased should not appear on background reports. Connecticut's Clean Slate law is comprehensive, and a significant volume of records are being erased on an ongoing basis. If your provider returns erased records, you're receiving information that shouldn't be accessible, and considering it in your screening decision creates liability. Ask your provider specifically about their compliance with Connecticut's Clean Slate provisions and how frequently they update their data. Connecticut limits the security deposit to 2 months' rent. The deposit must be held in an escrow account at a Connecticut bank or in the state's statewide banking institution, and the landlord must pay interest on the deposit at a rate established annually by the banking commissioner. The deposit must be returned within 30 days of the tenant vacating, along with an itemized statement of deductions. If the landlord fails to comply, the landlord may be liable for double the deposit amount. The 2-month deposit cap provides moderate financial protection, but given the prohibition on screening fees and the strong tenant protections, thorough and compliant screening is your most important tool for selecting reliable tenants. For the complete guide to Connecticut tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.